Today's episode is brought to you by Dr. Jeffrey Halstead, DMD. Dr. Jeffrey Halstead has been Canandaigua's hometown dentist for more than 35 years, offering routine dental care as well as cosmetic dentistry, implants, and dentures by their highly trained and experienced staff. Visit them online at canandaiguadentistry.com or find them on Facebook and Instagram. Today we are talking pay transparency. Earlier this fall, the New York State pay transparency law went into effect. In short, it mandated that employers post salary ranges when listing a job, but it went into effect in an odd time of year, mid-September. And many people are still completely unaware of the law, which was intended to limit potential discrimination. We have questions, and this hour I am joined by Jared Cook, Senior Counsel at Tully Rinke's Rochester office. He works in employment law and is here to share his expertise on how this might be interpreted by businesses and eventually the courts. Jared, thanks for taking the time today. We certainly appreciate it. Let's start with the simplest question I can throw out there to get us started. Give us an overview of the law. What's at play here?
But basically what it does is if you are advertising for a job, you're putting up a job posting, you have to put in there the salary range for the job. You have to say what you're going to pay. If you don't have it narrowed down to the exact figure, that's okay, but you have to make a good faith effort. You have to put a range in there. You know, we're going to pay between X and X per hour or per year, whatever it is. And the idea is that it's going to, in theory, cause people to know what different employers are paying for this job. The idea is that it's supposed to fight against pay disparity, whether that's disparity by race, by gender, whatever. The idea is that because if you look systematically, women and people of color are paid less for doing the same type of work than white guys like me. And so the idea is that if everybody knows what everybody's paying, then it'll be a lot easier for folks to say, well, listen, I'm not going to, I'm not going to accept that job if I know that somebody over here is paying more for it. Or listen, this is what you pay for this job. This is what you are paying everybody else. I should be making this. You should pay me the same, regardless of my age, race, whatever. So yeah, that's the idea. The idea is that if you just kind of get it all out there, get the information out there, then folks are free to kind of make their informed choices about whether they want to accept a job. And it's going to be harder for employers that are not paying the same to get away with that. And I should add also that it's not just employers that are intentionally discriminating, right? I mean, there are a lot of employers out there that have no intention to discriminate, but they are discriminating without even realizing it because of unconscious bias. And so you see that a lot. I'm aware of a couple of employers who, getting ready for this law to come into effect, they commissioned pay studies where they went and they paid a consultant to come in and look at all of their employees across the board, what they're paying each employee, and to put together a study and say, how are we doing? Are we giving equal pay for equal work? And they were surprised to find that they weren't, even despite their best efforts and their desire to not be discriminatory, there was unconscious bias. And as a result of that, they were across the board, there was a pattern of paying women and people of color less for doing the same work that they were paying, white men. So as a result, it brought them to see, hey, we've got some work to do. We need to make sure that we're being more fair in the way that we pay people. So there are a couple of ways that this law can advance that goal. One is, like I mentioned, people can, if there's transparency and everybody knows what everybody's paying, then, in theory, it'll make it easier for folks to negotiate and to be able to say, hey, why are you offering me less? I should be making the same. But it can also give employers a reason to uncover these type of unconscious biases that they have and see, hey, we're not doing as well as we thought. We've got to make sure that we're being more careful about this. So let's see. I've been seeing a lot, but you asked a question of, what is the law designed to do? That's the goal.
Yeah, I've got a few questions on kind of execution of this law and how it works in day to day for businesses and where kind of the legal hangups might be. Yeah. Is anyone exempt from this law? It seems to encompass every business from micro, small business all the way up to large corporation, but are there any exemptions that we're aware of?
I don't have the text of the law in front of me, but I seem to recall that it was all employers who employ 4 or more employees. Okay. So if you're a very small business, you only hire 1 or 2 people or something like that, then you may be exempt. But that's a pretty darn low threshold. A lot of other laws are 50 or more employees, or occasionally you see 15 or more employees. 4 is a pretty low. The idea is it really does cover just about everybody except for very, very small operations.
I will say, doing some prep the last couple of days for this interview, I've been scrolling through Indeed and some of the other job sites, and I have to say, it seems like, and this is anecdotal, but it seems like there is some non-compliance out there. What is the enforcement side? Like, how is this being enforced? Is this something that prospective job seekers are having to actually alert the state about this, or contact attorneys if they see fit?
Right. Yeah, it's a great question. The law is a little bit ambiguous about enforcement. It does say that anybody who is, the language they use is anybody who is aggrieved by a violation of the law can file a complaint with the Department of Labor. The Department of Labor is working on regulations to kind of flesh that out a little bit more, but even the regulations are still pretty bare bones. It doesn't define what exactly it means to be aggrieved. Generally speaking, in the law, you are aggrieved if you are some way harmed by a violation. So if if you were going to apply for a job, but you didn't because they didn't have the salary information, you couldn't tell if the job would be worth applying for, then you might be aggrieved. It's a little bit hard to think other than that, like what exactly it's going to mean to be aggrieved under this law. Under certain other civil rights statutes, there's something that's known as tester standing, where folks can actually go in to a business and test the business, see if they are accessible to, wheelchair accessible, for example. Or they can go and pose as buyers and attempt to buy a home as an interracial couple and see if they get discriminated against. And that courts have recognized that as being something that gives you standing to challenge violations. It's not totally clear to me whether that will be the case here. I don't know. The law doesn't provide incentives for plaintiffs to go out and file these claims. You don't get an extra payment. It doesn't clearly say that you get attorney's fees, for example. A lot of the other labor law provisions will say that if there's a violation, then you can get attorney's fees. If you win, then the employer not only has to pay you the wages that they withheld, but they have to pay your attorney's fees as well, in addition to liquidated damages and other things. So there's more of an incentive for folks to, go and hire a lawyer or file a complaint with the Department of Labor for those types of violations. For this one, it's not clear to me whether there's going to be as much of an incentive, because those types of payments and awards of damages and things, they aren't clearly written into the law. Now, I could see it conceivably, maybe the courts interpret it to say that some of the other provisions apply to this law, but that's yet to be seen whether that's going to happen. So I don't know that there's going to be much incentive for that type of tester standing, but generally speaking, when somebody is aggrieved, it's really a question of, do they have standing to complain about this violation? Now, the Department of Labor doesn't have quite the same standing requirements that courts would have. So if you're going to file a lawsuit and you're saying, they violate this law and it harmed me in some way, you have to show standing. Now, if you're going to the Department of Labor and you're just filing a complaint, it's really just a question of, do they want to investigate? Do they think that you've raised a violation that they think is worth investigating? So they don't have quite the same strict standing rules that the courts would have. And the regulations that have been proposed do say that the Department of Labor can initiate its own complaint, its own investigations if it finds. So they may have investigators that are, trolling Indeed and other job posting sites and just looking to see, are people complying? And if not, they may be writing some people up. I don't know exactly what their enforcement mechanism will be, if they will send out warning letters and give people some grace period to come into compliance. It's not terribly surprising that now only, a month and a half out, or no, I guess we're nearly 2 months at this point, but it's not entirely clear to me that, only a couple of months in, that there's maybe not the highest level of compliance. A lot of folks, particularly smaller businesses, maybe haven't even heard of it. You're a large company, you've got a HR department, dedicated in-house legal counsel. They're keeping you pretty well informed, and they're telling you, hey, you got to be careful. You got to make sure, you got this law on the books now. You're a mom and pop operation, maybe you're just barely over that threshold. You have 5 employees or something, you may not even know about it until the Department of Labor comes knocking and says, hey, you're not in compliance. I don't know if they will, like I said, give folks some kind of grace period. It's not written into the law that they need to do that, but as a matter of, enforcement discretion, they may decide like, hey, we'll give you a chance if you're quick about it. But that, I guess, will remain to be seen how the Department of Labor will enforce it.
One of the things I've been kind of curious about is just the likelihood, I guess, from your perspective, that we see a higher, I guess, than what would be average volume of cases related to this in the legal system. Like, do you anticipate challenges down the road to this from the business side of things? Do you anticipate seeing employees? I'm not even sure how that situation would arise, where an employee, a aggrieved employee, as you said, would take legal action. It doesn't really seem like there are many opportunities to see this kind of issue play out in court. Am I reading that wrong?
Well, I wouldn't say you're reading it wrong. It's a little bit different from a lot of other claims, because a lot of other claims, it's like, look, if you earned money that they didn't pay you, then you've got a pretty large incentive to go after that. If you were discriminated against in such a way that it caused you to lose your job, or to you're being paid less than other people, things like that, then yeah, there's an incentive. If you're just somebody that was looking for a job, and some of the postings you looked at didn't have the information. First of all, you might not even notice that as somebody who's just looking for a job. You may just scroll right past it without it even registering. Or maybe you notice it, but you're like, oh, well, that's annoying. I don't know how much they're paying for it. And you move on, and you forget about it. I imagine there's probably not going to be a ton of people that are thinking, they're violating the law and I need to do something about it. But maybe there will be. Maybe there will be folks who will make that claim to the Department of Labor. It doesn't look like the law, at least not explicitly, doesn't say that you can file a lawsuit over it, or that you'll get damages or anything like that. Again, the courts may interpret it in such a way that some of the other provisions apply. Or the courts may just say, there is what we lawyers call a private cause of action to be able to enforce that. So that means when you say there's a private cause of action, it means if they violated a law, if you have a private cause of action, it means that you can then sue them for that violation and say, you violated the law and it harmed me in some way and I want damages. Not every statute that gets passed creates a private cause of action when it gets violated. Some do, some don't. It's kind of a little bit of a complicated analysis. It depends on a number of different factors that the courts will look at. So it remains to be seen whether the courts will find one here. My gut feeling is they probably will not, especially because it does have an enforcement mechanism for the Department of Labor to, they will probably look at it and say, if you were aggrieved, if you have if it did harm you in some way, your remedy is to file a complaint with the Department of Labor. I've been wrong before, so I could be wrong here, and maybe there will be a private cause of action. But if I had to guess, I'd say they probably will leave it to the Department of Labor to enforce.
So one of the questions we got coming into this was what would be stopping that an employer from, say, posting a job with a salary range of, say, $1 to $1 million and just saying, this is how we're going to approach it.
Right. Yeah.
Is that something that could conceivably happen and there not be a ton without, the DOL stepping in and enforcing something, not be a lot of recourse?
Yeah. That's not a good strategy. I'll put it that way. If you came to me for advice as an employer saying, hey, I'm putting up this job posting, I want to know, how much latitude do I have? The standard is that you have to make a good faith effort to identify the salary range. So, if you were to say between $1 and $1 million a year, I don't think the DOL is going to look at that and say that represents a good faith effort. They're going to say, you're just being cute. You're just trying to, get around the law instead of complying with the law. You need to make a good faith effort. You don't have to narrow it down to the exact dollar, but I would put it this way: the narrower you do narrow it down, the safer you're going to be. The bigger the range, the more likely someone's going to question it. So, make a good faith effort. And if the range is still fairly broad, but you've made a good faith effort and you can defend that, you can say, well, it's broad because we are considering these different factors. We're considering, level of experience, level of education, whatever else. And we're willing to look at people with a wide variety of qualifications for this job. Then you can defend a fairly broad, range in salary. But the broader it gets, the more suspicion it will be looked at with, particularly because a very, very broad range means more discretion, and more discretion will raise eyebrows with, okay, well, is this broad range, this broad discretion going to be applied in a racially or gender discriminatory way? We've got a huge wide range. Does that mean that if we hire women or we hire people of color, we're going to pay them at the low end of the range? If we hire white men, are we paying at the high end of the range? Those are the kinds of red flags that will be raised by a very broad range.
Where, given that answer, and I'm going to try to pin you down here as much as I can. Yeah. Where does it start to get sketchy then? When you're talking about that range, when we're talking about, say, a job that may pay a median of $60,000, but you're posting that the range is $45,000 to $80,000. Where is that range where it may start to raise some red flags? At least in your analysis of this, where would you say, okay, whoa, pump the brakes and maybe get a little more narrow in how you're doing this?
I mean, that's a great question, and this may not be this very satisfying answer, but I don't think it's as much a function of the dollar amount of the range as much as it is, can you defend it? Is it tied to something real? Is it, I'm looking at hiring for this position. I'm looking at hiring people with master's degrees or people with people with a master's degree who is like all ready to step in the role. I'm also willing to look at hiring somebody who's coming straight out of high school and somebody who is willing to grow into the role. Obviously I'm going to pay them at a lower rate. And if you can defend that and it's tied to something real, then you're probably on safe ground. If it's just, well, I might feel like paying more or I might feel like paying less, that's not a very good strategy.
Fair enough. What is it? Because it seems like with items like this, with legal requirements like this for businesses, big, small, medium sized, it seems like the message is always, it's a good idea to have your policies and procedures in black and white, laid out clearly. Make sure you're in compliance with everything that's legally required at state and federal standards. How important is that when it comes to something like this? Because it seems like for 99.9% of businesses, this is a non-issue, a complete non-issue. Yeah. But for the 0.01% where it could be an issue, it almost seems like it would only be an issue for those who are maybe playing a little fast and loose with the rules and not really paying attention to the existing safeguards that are in place and intended to keep things like this from happening.
Yeah, no, I think that's probably right. I think it for those that are genuinely pretty careful about the law, they're going to be fine. And those that are, like you said, playing fast and loose, kind of trying to skirt the rules and kind of be cute with it, they're the ones that are going to get into trouble.
Gotcha. One thing you're watching on this front, obviously we're so early in the process right now. I'm curious, when we get to maybe a year out from implementation of this law, what's one thing that you're watching over the next 9 or so months to see how this really shakes out in real life?
Well, a couple of things that we kind of touched on this earlier, but I'm very curious to see how they get enforced. How does it get enforced? Do the courts say that there's going to be a private cause of action? Are they going to allow people to actually sue over this violation, or is it just going to be something that the Department of Labor will enforce by itself? That's one that I'll be looking for. Will there be decisions that say you can actually sue your employer, or I guess prospective employer, for these violations? Or is it just going to be, we're gonna let the Department of Labor investigate and issue an order if they find that there's a violation, and write people up, and that's just going to be it. That'll be interesting to see. The other thing that'll be interesting is whether does the Department of Labor, how seriously do they take it? How high of a priority do they put on it, right? Because they, like any state agency, they have limited resources. They can only fight so many battles. And so they really do need to make decisions and pick and choose about what their priorities are and, where are they going to focus on. So are they going to focus more on, really going after the egregious violators of paid discrimination laws? Or are they going to focus more on kind of these prevention type of efforts and say, we can't catch everybody that's breaking the law right now, but if we focus more on the prevention, then hopefully there'll be fewer violations down the line. And I don't know that one is necessarily better than the other. It's just, different styles of enforcement, different strategies, and whoever is in charge of the department at any given time will have, different ideas about the best way to enforce these things and to carry out the department's mission. So we'll see what they do.
All right, Jared, appreciate the time today. Thanks so much for taking it.
Yeah, no problem. Happy to do it.